Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Today's presentation is one of many by Synergy Settlement Services, a thought leader when it comes to settlement compliance. Tune in for our Third Thursday monthly webinar series and other presentations that will help you focus on what you do best. Today's presentation tackles the topic of settling cases compliantly, and I'll talk about trusts and liens when it comes to Medicare, Medicaid, and ERISA. My name is Jason Lazarus, CEO of Synergy Settlement Services, and I'll be your host as well as presenter for today. So let's jump right in. This chart is a quick reference guide for the different government assistance programs, their eligibility, whether they're asset or income sensitive, what the planning solutions are to keep the benefits in place, and also whether these programs have a lien or not. So keeping this handy and using it as a reference when you're settling cases will help you issue spot. Most trial lawyers by now have realized that dealing with Medicare secondary payer compliance at your firm is a very important issue in today's settlement landscape. This part of the presentation is going to focus on how to make sure that your firm does not get into trouble with violations of the Medicare Secondary Payer Act. If you make a mistake regarding the Medicare Secondary Payer Act and compliance with the law, you can wind up with the Department of Justice breathing down your neck. And that's exactly what happened to a Philadelphia law firm, which is one of several law firms that have now been pursued by the Department of Justice. And in this particular instance, it was over $6,000, almost $7,000 in conditional payments that had not been reimbursed. So even a small amount that hasn't been paid back to the government can wind up triggering a DOJ action. So in this particular instance, a Philadelphia law firm was sought after by the Department of Justice after failing to reimburse Medicare for clients who were Medicare beneficiaries who had Medicare conditional payments. So as part of the settlement, the firm agreed to pay back the $6,604.59, which again is a very small amount for the government to be pursuing, but it shows their seriousness. But not only that, the firm agreed to name a person responsible for paying Medicare secondary payer debts within the firm, training employees to ensure that the firm pays the debts on a timely basis, and providing written certifications of compliance. So as you can see, the government at the end, when it says lawyers need to set a good example and follow the rules of the road for Medicare reimbursement, if they don't, we'll move aggressively to recover the money for taxpayers, means what they say. This is another recent example of the DOJ pursuing a Baltimore law firm. This time, the firm had referred cases to another law firm who failed to reimburse Medicare conditional payments. And really what's an important takeaway from this is that when you are referring a case to another firm, you need to make sure you have three things: a written fee agreement, a copy of the lawyer's malpractice insurance policy declarations, and proof that that lawyer has engaged a company like Synergy to resolve Medicare conditional payment obligations. So in this particular instance, the U.S. attorney specifically said that plaintiff attorneys cannot refer a case or enter into a joint representation agreement with co-counsel and simply wash their hands clean of their obligations to reimburse Medicare for its conditional payments. And went on to say this settlement reminds attorneys of their obligation to reimburse Medicare for conditional payments after receiving a settlement or judgment. And importantly, this is no less true for plaintiff attorneys who refer cases to co-counsel or jointly represent plaintiffs. So you don't want to find yourself in a situation where you've referred a case to another lawyer who fails to address Medicare conditional payments, because you still could be subject to a DOJ action in that instance. I wanted to go through an actual fact pattern from a previous DOJ action against a law firm. So in this particular instance, the law firm provided notice to Medicare of a medical malpractice case. When Medicare was contacted, they issued a conditional payment letter indicating that Medicare had made payments of $14,990. The law firm relied upon that figure to settle the case. So when the case was settled, CMS was notified of the settlement. 60 days thereafter, a final demand was issued for $330,000. The law firm did administrative appeal, which was denied. So when this happened, when the denial happened, the U.S. Attorney's Office then sent a letter demanding payment. Because the law firm had already dispersed funds to the client, they turned it over to their E&O carrier, who paid a reduced amount from the $330,000. But there's a serious error here, which was the law firm relying on a conditional payment letter, which you cannot rely upon that. You can only rely upon a final demand that Medicare issues after they have settlement details. So be very careful, because you don't want to find yourself in a situation such as this. Given the confusion with many law firms about the process that must be engaged in when you're dealing with a Medicare conditional payment, I thought going through a summary of it is an important exercise. So the first step when you're representing a Medicare beneficiary is to report the case to the BCRC. When the BCRC gets the initial information, they'll issue a rights and responsibilities letter. BCRC will identify Medicare's interim recovery amount and issue that conditional payment letter, which, as I said on the previous slide, you cannot rely upon that. At that point, though, you want to go through the CPL and dispute any unrelated charges. So you want to do an audit verification of the amount that Medicare has put into the CPL. Once you settle the case, you need to send settlement notice to Medicare, and then a final demand is issued. So interest will start to accrue from the final demand if it's not paid, and after 90 days of non-payment, it gets referred over to Treasury for a collection action, and that's when you can see the DOJ get involved. So we've talked about all the bad things that can happen from ignoring Medicare conditional payments. Now I want to focus on the nuts and bolts of what you need to know about resolving Medicare conditional payments compliantly. It's important to know when resolving Medicare conditional payments that there's only three options. The first one is pay the amount within 60 days after you've done that audit verification I've talked about. The second is appeal the final demand amount, which is a very lengthy process because there's 5 levels of appeal before you ever get to fight it out in federal district court. And all the while, if the conditional payment has not been reimbursed, interest will accrue. And the third option is a post-final demand compromise and waiver. And I'll talk a little bit more about that in a moment. In terms of how Medicare is reimbursed, there are calculations that are laid out in the Code of Federal Regulations. So 411.37C deals with situations where Medicare payments are less than the judgment or settlement, and that's your typical procurement cost reduction based on that formula. 411.37D deals with the situation where Medicare payments are equal to or exceed the judgment or settlement. And in that instance, Medicare can take up the entire settlement. So I referenced this a couple of moments ago because many lawyers will engage in the Medicare conditional payment appeals process, which oftentimes causes the interest meter to keep running and a lot of time to be taken up by going through these different levels of review that are internal to Medicare. And if you look at these time frames, it's over a year that you spend fighting with Medicare before you ever get to a federal district court, and that can result in significant interest accruing, and typically it's not the most efficient or best way to resolve a Medicare conditional payment. Instead of going through the appeals process, typically it makes more sense to pay the Medicare conditional payment and then request a compromise or waiver. And there's 3 different provisions under which you can request a compromise or waiver. The first is a financial hardship argument under Section 1870C. That's done by the BCRC. They make the determination of whether your client meets the hardship definition. The second is a compromise under the FCCA. That's evaluated by CMS. You'll see there's different ways to assert that particular compromise or waiver, but basically it's looking at equitable type of arguments. And in that situation, you're looking really a lot at whether there is an inability to pay, cost of collection doesn't justify the enforced collection of the full amount of the claim. There were a lot of risks taken with the litigation, so there was a highly contested case and a limited recovery. So it's all those kinds of factors. The last one is kind of a catch-all, the best interest of the program, compromise or waiver. That's done under Section 1862B of the Social Security Act and is done by CMS. So if you are successful in making any of these requests, then Medicare can either reduce or completely waive the conditional payment amount. So if you're successful with a compromise or waiver, Medicare actually will issue a refund check. And that's a picture of an actual check on this slide where Medicare has refunded the amount that had been paid at the start of the compromise and waiver process. So our lien resolution group has a current success rate of 77% when pursuing a compromise or waiver. The average refund last year back to our clients was in excess of $16,000. Since we started doing this in 2013 through last year, we had recovered in refunds $6.8 million back from Medicare. So this is viable, and it's something that either you should be doing for your client or outsourcing it to a company like Synergy. Over the first part of this presentation, I spent a lot of time talking about Medicare compliance when it related to payments made prior to the date of settlement. One of the more complicated issues that continues to plague trial lawyers is what do you do when it comes to Medicare set-asides and the Medicare Secondary Payer Act related to futures. So I'm going to focus on addressing those issues in the next few slides and hopefully give you a roadmap to guide you in these issues. According to Medicare, there are 2 obligations under the Medicare Secondary Payer Act. One is from the date of settlement backwards, which is conditional payments that have been made in the past, and then the other is futures, so from the date of the settlement forward, and that's the Medicare set-aside issue. But surrounding all of this is Section 111 reporting, which is mandatory insurer reporting, where defendants must report any settlement of $1,000 or more with a Medicare beneficiary, which gives Medicare information on most settlements occurring today that involve a Medicare beneficiary. So the mandatory insurer reporting, where the insurer reports the details of the settlement, which includes the ICD codes, is important because it can act as a trigger for a denial of injury-related care. And why a denial is important is because if there is a denial, and while that's rare, it can happen because of this information that's being provided to Medicare by the insurers when they settle, you have to go through that same appeals process that I mentioned earlier when it came to conditional payments. So you've got a very long period of time that a client could go without Medicare coverage if they get that denial of care. At this point, we don't have any regulations or statutes that govern Medicare set-asides. It's all been policy created by Medicare, and Medicare tells us what their opinion is. That all has been an attempt made to codify. So this slide is a screenshot from the OMB website, and it's a process that's been started last year about codifying Medicare set-asides and compliance with the Medicare Secondary Payer Act when it comes to futures. Right now, we don't know when we'll see regulations. There has been a similar process in the past that resulted in no regulations. From our intelligence, we understand that Medicare is very serious about this process, and ultimately we will see regulations at some point, but right now we don't have anything definitive. We just know that there's a process going on to craft those regulations. So because we know the DOJ has gotten more aggressive about Medicare compliance, we know defendants have to report settlements with Medicare beneficiaries, we know regulations are potentially coming, law firms really need a process to make sure that they are identifying cases in their caseloads that involve Medicare clients. And if they are Medicare eligible, part of the process should be determining if future medicals are funded by the settlement, and if they are, then having a process to educate those clients on the risks of not setting aside, and then also having a methodology to select the appropriate solution to document the file and protect the client. So an easy way to remember this is CAD. That acronym stands for Consulting Experts, Advising the Client about the MSP, and then documenting your file. Documenting your file is critically important to making sure that ultimately you are protected from what would be really the only thing that could happen to you in this instance, which would be the client coming back and saying, I was not properly educated about these issues, and making a legal malpractice claim. There is no process by which the government can pursue a law firm for failing to do a Medicare set-aside for one of their clients. Ultimately, the client would suffer the potential ramifications of that, which would be Medicare refusing to pay for future injury-related care. So key points about Medicare set-asides. First and foremost, it's a gray area. As I said, there's no regulations or statute requiring a Medicare set-aside. In my opinion, it's like special needs trust, which I'm going to talk about in a moment, where if a client's on needs-based government assistance programs like Medicaid and SSI, you have a duty to explain to them that they can set up a special needs trust, which protects their future eligibility. Same thing with Medicare now. They have to be told that they can establish a Medicare set-aside, which can help protect their future Medicare eligibility. But remember, you only have to worry about this with clients who are a current Medicare beneficiary, so that's those that are disabled, age 65 or older, end-stage renal disease, ALS, or a disabled adult child. There's another category arguably of people that have a reasonable expectation of becoming a Medicare beneficiary within 30 months. Those are clients who are on SSDI and within 24 months will become a Medicare beneficiary. But remember, there are many alternatives to setting up a Medicare set-aside without shifting the burden to Medicare. Because if there is no burden shift to Medicare, then there's no need to address the Medicare set-aside issue. So some of those ways are client can elect into Medicare Advantage plan, Part C. They can switch over to private insurance. They can self-pay. They can do a trust for future medicals. They could set up a structured settlement to pay for future medicals. All those things can be done without having to do an MSA. But if a client is Medicare eligible, they've got to treat for their injuries in the future, and future medicals are funded by the settlement, that's when you need to consider a Medicare set-aside or some alternative. But going through the analysis is the important part to determine if an MSA should be set up. The MSA is Medicare's preferred method to protect the Medicare Trust Fund. So Synergy's Medicare Secondary Payer Compliance Group can ultimately assist you when you're dealing with these issues, help protect your client, and ultimately protect your firm. Our group can consult, provide a Medicare set-aside allocation, can provide the analysis to document your file ultimately if you don't do an allocation. If a Medicare set-aside is set up, our company can assist with funding solutions, structured settlements, and then a trust ultimately to help with the administration of that set-aside should the client need it. If a Medicare set-aside is going to be established, then a trust to manage the Medicare set-aside is usually something that should be considered. One type of trust that can be used to administer a Medicare set-aside is a pooled Medicare set-aside trust. That is usually set up for someone that's dual eligible, meaning they've got Medicare and Medicaid, or they're only on Medicare, but they need to have the Medicare set-aside properly administered. And that's when the pooled MSA trust can be established under the federal laws to professionally administer the set-aside. For most clients, it's incredibly difficult to self-administer a set-aside, so the Medicare set-aside is a low-cost arrangement that allows for the client to have a Medicare set-aside administrator who can manage the Medicare set-aside. A trust is preferable over many of the custodial arrangements that are out there in the marketplace because administrators can go out of business, whereas a trust goes on in perpetuity and there's a fiduciary duty on the part of the trustee. The pooled trust option gives the trust beneficiary an experienced set-aside administrator that can adjudicate the bills and manage the intricacies of reporting to Medicare, and as well as having the benefit of a corporate fiduciary. Before moving on from Medicare, it's important to talk about Medicare Advantage plans, which are sometimes referred to as MAOs or Part Cs, who can have a lien. And I call these hidden liens, and you'll realize here in a moment why I call that, but it's really important to understand the ramifications of not discovering one of these liens that could be out there. Medicare Advantage plans, sometimes called Part C or MAOs, are offered by private insurance companies that are approved by Medicare. An MAO will provide all of the coverages through Parts A, Parts B, and Part D. So Medicare pays a fixed amount every month to these companies that offer the MAO plans, and these MAO plans have to follow the rules set by Medicare. Although these plans have the same recovery rights as traditional Medicare, they are often much more open to agreements to reduce their liens based upon equity and fairness. But Medicare and Medicare Advantage plans are completely separate and distinct, and when trying to determine if there's a lien, you have to contact both. The scary part about Part C liens is that their recovery rights are in fact governed by Medicare, and the Medicare Secondary Payer Act does provide for a private cause of action for double damages when a primary plan fails to reimburse the Medicare Advantage plan for conditional payments it's made. The regulations extend that provision of the Medicare Secondary Payer Act to MAOs. So under cases and CMS memorandums, it's very clear that there is this right to exercise a double damages suit if a Part C lien is not reimbursed. And that lien can be recovered from not only the insurance company, and it shall be double damages according to the Western Heritage case, which is out of the 11th Circuit, but it could also be against the attorney directly. So what I referenced in the last slide about attorneys being potential targets for these double damages provisions is based on the provisions of the Medicare Secondary Payer Act, the statute, and the regulations. There are cases out there. There's one in particular where we were assisting a firm that was sued for double the amount of a Part C lien that they failed to reimburse the Part C provider for. The case was ultimately resolved confidentially during litigation, but the plan itself did sue the law firm, so the personal injury law firm. So you've got to be very careful about making sure that you are aware of any Part C plan liens that might be out there. So it's important to understand about Part C plans is that if you call Medicare and ask for their conditional payment amount, they will not include a Part C plan lien. They don't know about it because it's a private insurance company. And clients can move between traditional Medicare and a Part C plan post-accident. So you have to make sure that you are doing an investigation. So you've got to get copies of all the client's insurance cards and develop a process to train your staff to find these unidentified MAO liens that could be out there, because failing to do that could expose your firm to double the amount of the lien. And it's incredibly important to make sure that you've got a way to determine whether a client has treated with a Medicare Advantage plan. One of the tip-offs that you've got a hidden lien out there with an Advantage plan is if you know the client's treated and Medicare itself is telling you they've not paid anything, then it's very likely that the client switched over to an MAO plan. Our lien resolution group has a very high resolution rate for these types of liens. We get in excess of 59% reductions on MAO liens, so it is very possible to get a significant reduction on these liens. Now we're going to switch gears and focus on Medicaid. First up, I'm going to talk a little bit about Medicaid liens and whether there's a way to reduce them beyond the state reduction formula. Medicaid liens are a bit of a different animal since each state has their own third-party liability statutes, and it does vary state to state. For example, in my home state of Florida, we have a provision 409.910 that provides a standard reduction formula, and then if you want a further reduction, you have to argue it before an administrative law judge at the Division of Administrative Hearings. Since each state has tackled this differently, really what you have to do is use your state case law, whatever exists on this point, combined with the federal case law. So the federal case law started with Allborn, which basically limited Medicaid's right of reimbursement to only the damages that are properly allocable to past medical expenses. Subsequent to Allborn, another case went up to the U.S. Supreme Court called WAS, which is the case cited on this particular slide. In that case, the U.S. Supreme Court basically affirmed Allborn and reviewed North Carolina's third-party liability recovery statute and found that it violated Allborn because it was incompatible with the federal anti-lien provision and allowed for basically the attachment or encumbrance of payments that were designated as payments for medical care or other than medical care. So the problem ultimately that the Supreme Court addressed was this statute that required this reimbursement that violated Allborn. So when you are faced with a Medicaid lien in your state, you have to figure out what your state's law is, how you can effectively use Allborn to reduce. And some states are great. My home state, as I said, Florida, is not great. They have a third-party contractor who's very aggressive and will only reduce based on the statute. And the statute is very similar, actually, to North Carolina's. So personally, I think if it was ever challenged, the Supreme Court would find it violates Allborn. But nevertheless, you have to make arguments based on your state and use Allborn and WAS effectively to argue why there should be a reduction, and use the formula that Allborn used, which is basically a pro rata reduction of all elements of damages based on the ratio that's created from the full value of damages compared to what was recovered. So continuing now with Medicaid and also SSI, we're going to turn to the types of planning mechanisms that need to be thought about and explored when a client needs to preserve their needs-based benefits and is disabled. So if you've got a client who is on Medicaid and or SSI, is disabled, then you should consider whether a special needs trust is appropriate. So you've got to have both the public benefit coverage that is needs-based and a qualifying disability under the SSA definition of disability to then consider a special needs trust. If you only have needs-based benefits coverage issues, the problem is that without a disability, you can't create a special needs trust. So for clients who do not have a qualifying disability, there are very limited ways to plan for them. So for clients who are disabled and receiving needs-based benefits and you settle a case for them, there are several different types of trusts that can be established to preserve Medicaid and SSI eligibility. The first is what I call a D4A or standalone special needs trust, which can be created for anyone that's disabled under the age of 65. The next is a D4C or a pooled trust. Those can be created for someone that's disabled but of any age, so the 65 age requirement is not part of that under 65, so it can be used for anybody. Last are third-party special needs trusts. That's where perhaps the community did a GoFundMe, or there's life insurance proceeds from the death of another family member, or there's an estate that's potentially going to be left to a client who is disabled by a parent, grandparent. Third-party trusts are for monies that are not the client's own monies. So the D4A and D4C are called first-party trusts. They're the client's own money. A third party is set up when it's not the client's own money. So for special needs trust, the advantages of creating it, it keeps the eligibility intact, gives the client a professional trustee. In most instances, you want a professional trustee because the rules regulating Medicaid and SSI are very complicated, and most clients and family members have no ability to understand or interpret those correctly. For clients that are minors or incapacitated, it can typically avoid guardianships and annual reporting requirements. And these types of trusts are available to pay for nearly everything except food and shelter. And that food and shelter restriction is only applicable if the client's on SSI. So what are the disadvantages? Well, client doesn't have unrestricted use of their funds. The trust can only be used for their sole benefit, so they can't pay for things for their kids, other family members out of that trust. It can only be used for them. At death, Medicaid must be paid back for any monies that Medicaid has expended on that person's behalf, and that's separate and apart from any third-party liability liens that were paid back already. And that's required under federal law. Every special needs trust must have it. The only exception are third-party trusts. So if it's not the client's own money, there's no payback. Obviously, anytime you have a trust, it's an extra layer of complexity, and these types of trusts have to be irrevocable. Two things to keep in mind. One is deeming. What deeming is when a parent gets a settlement is deemed to their minor child, so the minor child becomes ineligible. Same thing between husband and wife. So this can become a real problem in cases where there's consortium claims. So say you've got a birth injury, child is going to get $2 million. You put all that money into a special needs trust. You give mom and dad each $100,000 for their consortium claims. You've just disqualified that minor child because mom and dad's recovery is deemed to that minor child. So you have to be very careful about how the settlement is constructed. And the last thing is exempt assets. So you don't always need a special needs trust. There are settlements where the money is on the relatively smaller side, where the money can be simply spent down on exempt assets. Exempt assets are house, car, home furnishings and belongings inside of the house, so furniture, electronics, appliances. So there are ways to get around having to create a special needs trust by spending down on exempt assets. But you have to have a plan, and you have to make sure that that plan complies with the rules regarding spend down. And those are not simple, but there are rules to follow, so you just have to be cognizant of that. For a moment, I want to focus on pooled special needs trusts because they are ideal for use in personal injury settlements because they're easy to set up and cheaper than standalone special needs trusts. So using them as part of the plan to preserve Medicaid and SSI eligibility makes a lot of sense in personal injury cases. Pooled trusts are different from standalone special needs trusts in that there's no age restriction applicable, so someone over 65 can join a pooled special needs trust, and that's oftentimes in elder abuse or nursing home cases, a pooled trust is the only option. But it makes a lot of sense across all personal injury settlements to use it because the trust beneficiary joins an already established master trust instead of having to have an individually crafted trust document. The way they join it is by completing a very simple joinder contract agreement, so it's very quick to establish it. So the advantages to using this type of pooled trust is that it's managed by a not-for-profit 501c3 under federal law. Most of these trusts have a very low annual fee, and most don't have a minimum trust size. So you could put as little as $10,000 into a pooled trust. That would be exceedingly difficult to do in a standalone. Most trustees who will do trust administration for a special needs trust want $500,000 to $1 million because these trusts are difficult to manage. So having a not-for-profit makes a lot of sense. And in terms of what to look for in evaluating pooled trusts, there's a couple of different things. You want to make sure that the not-for-profit trustee understands personal injury settlements. Most pooled trusts are established for the elderly, and they're set up for people trying to qualify for nursing home coverage by Medicaid, and they don't understand PI settlements. So you want to find a pooled trust that does understand personal injury settlements. You also want to make sure that the trust offers what you would find in a bigger bank or bigger trust company trust in terms of services. So, for example, TrueLink and Team are two services that are integrated into a trust I helped establish for personal injury settlements. And TrueLink provides some pretty unique investment advisory services, has a smart credit card that can be used to easily spend the trust monies, which is a very important thing to have in terms of services. Team is a service that allows family members to be hired as caregivers and get workers' comp coverage, have payroll deduction, all that kind of stuff. You want to make sure that the pool trust you're evaluating has an economical fee structure. Any fee in the 1.5% to 2% total fees, so that includes trustee and asset management fee, is a pretty reasonable and economical fee structure. You also want to look at retained funds policy. So at death, pooled trusts have differing policies on retaining monies. A lot of them will retain 100% of the settlement, which you certainly would not ever want to enter into one of those pooled trusts. But some, like the one I'm involved with, has a very low amount that's retained. So you want to evaluate that. And then you want to look at the philanthropic purposes of the not-for-profit, because if they do retain some of the monies, then obviously you want to make sure that those monies are used for good purposes. All right, so we've hit Medicare and Medicaid. So I left the best for last, ERISA liens. And this is a bit of a complicated subject, so this is just going to be very high level, give you an overview about how to make sure that you're still getting reductions after the McCutcheon case, which was a very unfortunate decision by the U.S. Supreme Court that really strengthened the resolves of these ERISA plans to be very difficult in terms of resolving their liens. So when dealing with ERISA, the very first question is this really an ERISA plan? So ERISA governs employer-employee plans, but it does not cover the federal government. In that case, FEBA would apply. If the employer is the state government, state law will apply. If the employer is a church, state law will apply. So those are situations where it would not be ERISA. So the next question, if it is truly a plan covered by ERISA, is it a self-funded ERISA plan or is it insured? If it's a self-funded ERISA plan, then state law is preempted. And that's important because if state law is preempted, then you're left with the McCutcheon case and all the other cases under federal law that interpret an ERISA plan's recovery rights, and they're pretty strong. So if it is a self-funded, that means that the plan is funded by the contributions from employer and employee. Now, contrast that with a fully insured plan, which would be subject to state law. That's where it's funded by the purchase of insurance coverage. So smaller employers typically are going to have fully insured plans. Now, the question is, how do you know if it's self-funded or insured? Really, the only way to know is to review certain documents. One is the master plan and the summary plan, the Form 5500. You want to ask the plan administrator or recovery agent. A couple of shortcuts. If the plan is named the employer group or titled as an ASO, then it's likely self-funded. If the plan is named an insurance carrier or titled HMO, PPO, or POS, then likely it's a fully insured plan. So if you've gotten 2 yeses, meaning it is definitely a plan covered by ERISA and it is definitely self-funded, that's when you want to take advantage of making a 1024B4 request. This provision of federal law provides a list of what the ERISA plan administrator must provide upon request. That includes a copy of the summary plan description, latest annual report, any terminal report, the bargaining agreement, the trust agreement, contract, other instruments under which the plan is established or operated. The Administrative Services Agreement is subject to ERISA disclosure requirements as it's a document that restricts or governs a plan's operation. So that's a lot of documents that you're entitled to, and I can tell you that ERISA plans typically don't want to turn over all of those documents. One thing that you have to make sure of is when you make one of these requests, you have to make the request of the correct party. The disclosure requirement is imposed upon the plan administrator. You can't send the request to a third-party administrator or recovery vendor. So if you send this to Rawlings, Conduit, Optum, you're sending it to the wrong place. You have to send it to the plan administrator. So if you make a 1024B4 request and the plan does not comply, there are penalties. And this slide outlines those different penalties and shows cases where those penalties have been imposed. And the great part about these penalties is that if the documents are not provided and these penalties begin to accrue, it gives you a lot of leverage to then negotiate a reduction with the ERISA plan because the penalties could exceed the lien amount. So with ERISA plans, what's your plan of attack? This is why it's so important to get everything under 1024B4. As I said, you want to trigger those penalties, it gives you leverage, and then you want to also be able to get the documents so that you can check the plan language, make sure, first of all, if it's a first-party case, that the plan actually reaches first-party coverage. A lot of times that is silent or vague in the documents, the plan documents. You want to make sure that the language overcomes the made whole doctrine. If you're in the 11th, there's specific plan language that's required to abrogate made whole. You want to also make sure that the plan language overcomes common fund. If the language is silent, then a reduction of attorney's fees may be appropriate. And that's some of the language comes from the McCutcheon case, which does reinforce that it has to specifically abrogate these doctrines. So that wraps up today's presentation. Hopefully it gives you a good roadmap for dealing with clients with disabilities. This is a picture actually from our annual conference, and I show that because we had a guest speaker who, as you can see in the middle there, is disabled. He was shot at a young age by a friend who thought a gun was not loaded and instead unloaded a bullet into his spinal cord. Very inspirational guy, but I had him come speak at our annual conference because I want every member of our team to understand exactly what it is that an injury victim goes through when they have experienced the type of catastrophic injuries that this gentleman had. And every month we go through cases and highlight how Synergy has helped people that have been catastrophically injured to continue to illustrate to our team the importance of serving the injury victims that we get the opportunity to assist to help them transition from litigation to life, whether it's putting more money in their pocket by resolving liens or whether it's helping preserve public benefits or protecting their financial future. It's very important to me ultimately that our entire team recognize the importance of who we serve. So that's me. If you have any questions about today's presentation or want a copy of the slides, shoot me an email at jason@synergysettlements.com or give me a call at 877-242-0022. Before wrapping up today's presentation, I wanted to take a moment to tell you a little bit about Synergy. So Synergy provides efficient healthcare lien resolution, cutting-edge Medicare secondary payer compliance services, settlement consulting and planning, critical government benefit preservation techniques, structured settlements, easy-to-use trust services, and lastly, solutions to defer taxation of contingent legal fees. It's everything that arises at the end of the case that can be complex and cause issues at settlement with getting to a compliant resolution. Those are things that Synergy can help with, what we call the case after the case. By dealing with these issues for you, you get to focus on what you do best, be a trial lawyer.